2014 Retirement Plan Regulatory Update. My name is Megan Whitaker, and I'm a benefit analyst here at Multnomah Group, and I'm here to introduce our presenter for today. Before I do, I'd like to go over a couple of housekeeping items. So first of all, we are recording this session. All of your lines are muted throughout the presentation. I will be sending out the slides and the recording of the webinar via email no later than tomorrow. And we're also going to have the recording and the slides posted to the resource center of our website if you'd like to go back in the future to reference it. Second, if you have questions throughout the presentation, feel free to use the Q&A box in your control panel to submit your questions. Amy will do her best to get to all of them, but if we run out of time, she can follow up with you individually and make sure we get all of them answered. So now I'd like to introduce our presenter for today, Amy Barber. Amy is the Chief Compliance Officer and Director of Technical Services for Multnomah Group. She is responsible for the development, implementation, and oversight of the firm's regulatory compliance program. Before joining Multnomah Group in 2012, she worked as an attorney in private practice with a focus on providing regulatory compliance advice and services to both SEC and state-registered advisors. Prior to that, she was the Director of SEC Compliance and an investment consultant for another SEC-registered investment advisory firm. Amy earned her JD and federal tax law certificate from Lewis and Clark Law School here in Portland, Oregon. So Amy, I will let you take it from here.
Great. Thanks, Megan. Thanks, everybody, for joining us today. I'm going to go through a couple different topics for our 2014 regulatory update. Although I apologize, right? Oh, there we go. Couldn't get the slide to change. So here's the agenda. You know, compared to the past few years, it's been kind of a tame year as far as required regulatory issues. There are a few things that have been discussed for a while that are out there on the horizon. And then a couple things that, just from an operational perspective of working with some of our clients that I found of interest. And then lastly, we'll discuss some case law that is recent out there that deals with some of the issues that fiduciaries should probably consider in light of some of these recent cases. So the first thing I'm going to talk about is the main regulatory requirement going on right now, and that's basically the restatement period for prototype or volume submitter plans. The majority of defined contribution plan sponsors use these types of plans versus an individually designed document. So if you are on a prototype or a volume submitter plan, right now we're in the 2-year window where plans must be restated. Basically, the documents are updated from time to time due to changes, tax laws made by Congress or regulations under the IRS or the Department of Labor. So basically what this restatement period does is it incorporates interim amendments that have occurred over the last several years, and it incorporates it in a new restated plan document that's kind of clean and goes forward from there. The window for the restatement period opened on May 1st of this year, and it closes on April 30th of 2016. So you're likely to be hearing from your plan document provider when your kind of number comes up to get restated onto their new plan document. So if you're on a current Fidelity plan document, your Fidelity rep will be contacting you, or should be contacting you. If you don't hear from them, maybe within like the next 6 months, I would probably just ask them where you fall on the list, but you should be hearing from them to get you onto the newly restated document. If you're a plan sponsor that has more recently started a plan, and you started that plan prior to probably April or May, or excuse me, May of this year, you likely still need to restate your document, and that's because the old volume submitter plans only incorporated the prior stuff. The IRS hadn't issued their advisory or approval letters until the end of April of this year. So the plan documents hadn't been, the new revised plan documents hadn't really been available for use to plan sponsors. So even if you started your plan on May 1st, you're probably not on the document that's required, and you're still going to have to restate your document within the 2-year window. The reason you want to do that, here on the slide, if you fail to redo that, there's unintended tax consequences, potentially disqualification of your plan. So if anybody has any questions about that, feel free to post that in the chat message, or you can always contact us after the webinar is over. I should add that those restatement, the restatement period is for qualified defined contribution plans. They're not 403B, not for 403B plans. I'll actually be touching on that in a couple slides later in the presentation. So interim and good faith amendments. Those are the amendments that occur that are required to keep the plan document current. And I've made a note here that for plan sponsors who restate their plan after December 31st, 2014, which most, I would say the majority of people doing the restatement period will be doing it after December of this year, you potentially may be required by the end of the year to have an amendment to comply with IRS guidance on same-sex marriage. Basically, due to the Windsor decision, we're going to talk about DOMA in a second here also. Certain amendments are required by December 31st of 2014. I would imagine if you're on a volume submitter or a prototype document, there's not going to be much to do in a way of a Windsor amendment. If you're on an individually designed plan, you may need to look at your plan language to determine whether or not a restatement is required or an amendment is required. And then plan sponsors can also adopt discretionary amendments, and those just need to be adopted by the end of the plan year in which the amendment is to become effective. One thing about this mandatory restatement period that we talk to our clients about is kind of deciding, since you're going to have to restate in this 2-year period, is there anything that you want to do to make changes in your current plan document? If you haven't had an automatic contribution arrangement in the past, are you interested in doing that now? It would be a good time to incorporate that. Or if you haven't added an option for Roth deferrals, is that something that you want to add? So kind of get started thinking about the things that you might want to do if you're going to be, if you're going to fall under this required restatement period for volume submitter or prototype documents. So the next issue I'm going to talk about is DOMA, and for those of you who may have been on Eric Bailey's presentation last year, DOMA was kind of new at that time, and there was a lot of uncertainty of what was going to be required of plan sponsors. Basically, the U.S. v. Windsor decision ruled that Section 3 of the Defense of Marriage Act was unconstitutional, and now the term spouse refers to a same-sex spouse, whereas DOMA only referred to it as a person of the opposite sex. At the time of Eric's presentation, what the Windsor decision didn't do was, federal law would defer state by state to determine whether same-sex couples could marry. So the federal deferred to the state. It didn't discuss whether civil unions, partners were spouses for federal law purposes. The decision at the time didn't provide any guidance as to which state marriage law should control for various federal law determinations, and it didn't determine whether or not same-sex marriages, whether there were any retroactive rights. The one thing that I think primarily has changed, and per this slide, the IRS has issued a notice and some guidance regarding the retroactivity of Windsor to qualified plans. The one thing that I would point out is that now versus when Eric gave his presentation, there was a lot of questions as to whether or not a plan sponsor in a state that didn't recognize same-sex marriage, if they had to recognize same-sex marriage performed in other states. Now it's clear that they do, where the state, if the marriage is legal in the state that it was celebrated in, that has to be recognized in a state, even if that state doesn't recognize same-sex marriage. So an important part of this is there's no amendment that's going to be required to your plan if it's operated in compliance with Windsor, and the subsequent IRS guidance, and the IRS had given the example when the term spouse or legally married spouse or spouse under federal law, if those definitions are used, you know, those will be compliant with the Windsor decision, versus a plan document provision that defines spouse as, you know, the spouse is the definition under DOMA, which would no longer be acceptable, and you would have to do an amendment to make your plan in compliance with Windsor. The deadline for the majority to adopt plan amendments is December 31st, 2014 for the majority of plans. So moving on to, similar to the restatement for the volume submitter and the prototype plans, the 2-year period that we talked about initially, the 403B plans, back in 2013, the IRS put forth an option that they're putting together an option for pre-approval plans for 403B plans. The IRS said they're not going to provide a determination letter for individually designed 403B plans. So if you're on a individually designed 403B plan and you want assurance that your plan is in compliance with, you know, blessed by the IRS, you would have to switch it when this period opens. You would have to switch to a volume submitter or a prototype plan document. You're not required to do that. It's just if you want the blessing of the IRS that, you know, your plan is in compliance and pre-approved, you would have to get onto this new type of plan document. So vendors, you know, your TIA crafts, et cetera, they begin submitting their plan documents to the IRS for approval back in 2013. The submission window was supposed to close on April 30th of this year, but the IRS had extended it a year. Once the IRS issues their approval letters for these 403B plans, employers would have at least a year, potentially 2 years. That's a little unclear from the new revenue procedure, but at least a year, so no earlier than April 30th of 2016 would you be able to get onto the new 403B pre-approved plan document. We expect future guidance that would require pre-approved plans to be restated kind of along the same time frames as the remedial amendment cycle for the 401k type plans, but that remains kind of a question at this point. So another thing that's kind of on the horizon, there's a proposal for a summary guide for 408B2 plan disclosures. One of the things when these 408B2 regulations came out a few years ago is that kind of everybody has their own style of putting together their information, and it kind of makes it hard for plan sponsors to digest all of the information. So the Department of Labor has proposed a summary guide where covered service providers will provide their information pretty much in the same format, so it makes it easier for the plan sponsors to kind of digest all the information. Although the proposal does say that a guide would not be required if the disclosures are contained in a single concise document. So if you have one document that says, here's what our fees are, here's here's our indirect compensation, et cetera. If you have one single concise document, you wouldn't have to actually provide a guide. But if you're a vendor giving the plan sponsor information that says, refer to our ADV for this information and refer to our contract for this other information, that's when the guide would come into play, so that people could find the information more efficiently. One of the changes to the information in the guide is that these guides would only have to be furnished annually. That's a little convoluted because it says it also said that guides for plans entering into new service arrangements are required to contain current information. So if I'm a provider and I'm only required to provide information to my current clients annually, they get one document, but I also have to keep my information current for any new clients that come on. So if information changes, the new client that comes on board has to get my new guide. So you're still required to keep it up to date in real time, even though you're only required to provide it to a client once a year. So that's something that we're going to need some probably clarification on. The Department of Labor had requested commentary as to the page length criteria, etc. And people had provided comments that deadline ended on June 10th, but there's no deadline for final action at this time. Another item that's kind of on the horizon is there's been a lot of DOL interest on annuity illustration in benefit statements. Basically, the Department of Labor is concerned that participants, they see a balance on their plan statement and they view it as their wealth. They have $80,000 in their retirement plan. The problem is the Department of Labor is concerned that that participant doesn't really understand what that translates to in retirement. And that having $80,000 may look like a lot of money to someone today, but when you think about how much that's going to pay out over, 25, 35 years in retirement, the participants aren't making that connection. So right now, they published an advance notice of a proposed rulemaking. Most, I think, people in our industry consider whether or not that's going to be a mandate or whether or not that's going to be just something that's encouraged. There are a lot of tools out there for participants that are provided by the record keepers. The problem is that most participants don't use them. So the DOL, I think, really wants to see something on the statement that shows that to the participant, and maybe if that's the one thing that the participant looks at, that will help them, make changes in their savings habits. Again, kind of remains to be seen whether or not it'll be mandated or whether it's just kind of a guidance, whether there's any kind of safe harbor that might be issued, and if so, what would the requirements of that safe harbor look like? I mean, are they going to give guidance as to the assumptions that should be made, interest rates and growth rates for the people who are putting together the assumptions on the annuity statement. So hopefully there'll be some guidance that provides some uniformity to that. Another issue that has been out there for a little while is questions regarding a fiduciary's requirement to provide oversight on self-directed brokerage windows. We think this is probably still a few years out. The Department of Labor had planned to issue a request for information. Once the request for information goes out, there's got to be proposed rulemakings and, commentary on it, and then so it's probably at least a few years out before anything comes to light on this. Part of the concern in the industry is it's fairly impossible for a fiduciary to effectively monitor performance of outside brokerage accounts. I think it was Vanguard. I think I read that Vanguard says about 20% of their participants have self-directed brokerage accounts, and I think Fidelity was around 10%. So there's a lot out there, and people do consider offering brokerage windows to their participants. But again, it's this balance of, would fiduciaries really want to take on that obligation of monitoring and overseeing those accounts? So we'll have to wait and see what comes to light on that RFI project. The Department of Labor's spring update agenda estimated it would be released in May, the RFI, but it wasn't. So we're still waiting on that. Another on the horizon is this uniform fiduciary standard for brokers and advisors. Back when the SEC, when Dodd-Frank was enacted, you know, the Dodd-Frank didn't require the SEC to actually adopt a rule. It just required a study on it. And there was some comments by SEC Chairman Mary Jo White that she said basically instead of proposing a rule, they would make a quote, threshold decision whether to even proceed with a rulemaking. So it kind of seems like this has been kind of put on the back burner, which isn't really surprising. There's been probably a lot of commentaries coming out of this from the brokerage side about the uniform standard, what that would mean to their practice, et cetera. In contrast to that, the Department of Labor continues to list a revised fiduciary definition on its regulatory agenda, but it's been pushed back again to January of 2015. And from the DOL side, this has been out there since, I believe, around 2008. They had actually finalized a rule, and then they pulled that rule, and so it's kind of been hanging out there since then. So another one of those things that we'll wait and see what happens on that. So from an operational perspective, I thought it would be interesting to talk about a couple research items, at least I've come across, and one of the sources of information I go to is through the American Bar Association. They have a section on taxation. They had a meeting back in May where, you know, basically there were IRS representatives there. There were question and answer sessions. And the one thing, I guess, that is important to note is these are non-binding interpretations. These are questions that were submitted by Bar Association members that were answered by the reps that was there, but they're unofficial, just individual views of the service representatives. They don't necessarily represent agency policy, but the reason I'm bringing them up is from an operational perspective, we see a lot of issues with loan default and the repayment of loans, and it's just some guidance for plan sponsors to maybe think about what their plan documents say, what their practice is, and, you know, based on maybe this kind of information, if you want to take a look at whether or not you need to reevaluate what your practice is. And so one of the items that I read about, and again, this was from their May 9th, 2014 meeting, talked about loan default. And the IRS representative said, in their opinion, again, non-binding, unofficial IRS interpretation, is that a 1099 must be issued when a borrower fails to make a loan installment payment by its due date. So if a participant takes out a loan, you know, pays it back for, you know, a couple months and then misses a payment, what this representative seemed to indicate is that at that time, an operational failure will occur if the employer doesn't default the loan and issue the 1099. And that's a failure that can only be corrected through VCP if it is something that needs to be corrected. Another question came up on loan repayment, where the loan must be required to be repaid within 5 years. This meeting basically reiterated that neither the code nor the regulation specifies when a 5-year period begins. The regulations say that a loan has to be repaid within 5 years from the date of the loan. The issue for plan sponsors, I guess, to think about is that a lot of record keepers treat the start of the 5-year repayment period as the date the payment is first withheld from the borrower's pay. The IRS representative stated the date of the loan is supposed to be specified in the terms of the plan agreement, and the representative noted that the start date can't be after the loan is funded or after the loan proceeds are paid to the participant. That's the very latest of when the loan start date should be. So, and I think maybe I fumbled. I said record keepers treat the start of the 5-year repayment as the date the first payment is withheld from the borrower's pay. So the repayment period can't start on the date, according to this representative, it can't start on the date it's withheld from the borrower's pay, like the first payment. It has to start on the day the loan is funded. So something to look into regarding your own operations, how you handle that. There was another IRS interpretation that had to do with reinstating contributions after hardship, and another point that you should look specifically at what your plan document language says. If your plan document specifically says that you will reinstate a loan after the 6-month suspension, you should have processes and procedures in place to make sure that that occurs, unless you have some sort of grace period built into your plan document language. So, you know, for example, if you have somebody that takes a hardship and you suspend their payments for 6 months, and then 9 months goes by, and they say, oh, I want to reinstate my contribution. There could be operational issues there if you didn't do it automatically. And again, it depends on what your plan document language says. It's just very important. I think this interpretation is just very important for plan sponsors to actually go back, look at what's required of them, and then making sure their policies and procedures are corresponding to that document language. So the last thing I had on the agenda today to discuss was a couple of cases that are out there that are interesting from a plan sponsor's fiduciary perspective. Tussey versus ADD was a pretty substantial case that initially the district court, I think, decided in 2012, if I'm not mistaken. And there was a lot of money that the fiduciaries for the plan were required to pay. At the time of that district court decision, Fidelity, who is the record keeper, also had an award levied against them. Basically the case was appealed, and it was a split decision on appeal. But basically, the decision upheld the ruling that ABD had violated its fiduciary duties, and I'll go into the details of that in just a second, on failing to control record-keeping costs. They upheld that award of $13.4 million to the plaintiff. They vacated an award of $21+ million regarding a decision to map funds that apparently were doing well to another set of target date funds. But it reversed the decision against Fidelity, and that had to do with the allegation was improperly managing float income. I won't get into the details of the float income piece. It's very technical. But I think the one thing for plan sponsors to take away from this case is that they should probably look very closely at their record-keeping agreements with their vendors and see if those agreements say something about the float income, who gets to keep it, or is it silent? Because that could that was part of the problem here, that there wasn't anything disclosed about who could keep the float income. The fiduciary issues in this were, there were quite a few fiduciary issues in this. One, at the district court level, it talked about ADB not following its investment policy statement. And in the ruling at the district court level, the district court had found a fiduciary breach for failing to follow their investment policy statement. The appeals decision actually didn't even get to the investment policy statement issue. They said that there was a fiduciary breach based on other issues, so they weren't going to, they weren't even going to get to that, because ABB had said that the district court had incorrectly ruled on that issue. So we don't have the clarity that would have been nice to have regarding investment policy statements in relation to this case, but I do think a takeaway for plan sponsors is that questions are out there. If you have an investment policy statement, make sure that it's broad enough to give you discretion to deal with certain situations. Make sure it's not too restrictive in what you're required to do. For example, an investment policy statement that says before you terminate a fund, you must put the fund on the watch list. That may not be such a great idea for a number of reasons. I mean, there could be something that happens with a fund that makes an investment consultant recommend that you get rid of the fund out of the plan now versus putting it on a watch list for 3 months. So that was one of the things in this Tussey decision that a fund wasn't put on the watch list, which is what the investment policy said. The other thing, which was probably a really big deal in Tussey, which the appellate court did talk about, is that they failed to monitor the record-keeping costs. Their investment consultant had told them, you're paying too much to your record keeper for services that are going to the plan. Well, what happened in Tussey is that Fidelity had been providing services to the corporation, payroll services, et cetera, that weren't really in relation to the plan, and the plan fees were basically subsidizing those costs, which is a big problem. So an important takeaway in that respect is that review your record-keeping costs, and part of the 408B2 requirement to ensure that the services the plan is receiving are reasonable in light of the services that you're receiving. So that was Tussey. There's another case out there. It was recently, actually, just a few weeks ago, Tatum versus R.J. Reynolds Pension Investment Committee. This was another fiduciary case that's important in the sense that it reiterates that there's a high bar that's necessary to satisfy the test of whether a plan fiduciary is making prudent decisions. This case rested on some decisions to get rid of a certain stock fund out of the plan, and R.J. Reynolds basically tried to argue that a prudent fiduciary could have made the same decision they made. And the court came back and said, could have versus would have, the difference is a decision that's maybe possible versus one that was probable. And plan fiduciaries, in order to meet their fiduciary requirements, need to be making decisions that are what other plan fiduciaries would do, not what somebody could do. If you can find one prudent fiduciary that could have made the same decision as you, but 100 other ones would have made a different decision, they're saying that would set the bar way too low for fiduciaries. So it's basically what a prudent fiduciary would do in a certain situation. The last page is my disclosure, our disclosure page. There's one thing I guess I would add to the court cases. There's been a lot of cases out there that have to deal with church plan status. A couple in California, and I don't recall off the top of my head where the other cases are located. But there's been about 3 decisions recently that the district court level has come back and said, the church plan doesn't meet the standard under ERISA to be a church plan. Those courts have said a plan must be established, not merely maintained, and that's what ERISA requires, is that a plan be established and maintained by its employees. So if a church doesn't actually establish the plan, in these cases, it's not enough that an organization affiliated with the church maintains the plan. So it's something if you're a plan sponsor that currently has a church plan, you might want to speak with your counsel to see their thoughts on, what these cases mean for you. We don't have any real there's no real authoritative decisions on church plan status yet. These have all been cases at the district court level. We're waiting to see if any of them make it to the appellate court level so we can get some kind of further guidance on how certain districts are going to handle, certain circuits are going to handle the application of these decisions. But it's something that's out there that if you are maintaining that you do have a church plan, you may want to speak to your counsel and determine where you go from here, or if you go anywhere, and maybe just kind of sit back and wait and see what happens on these cases. So that's, I got through that a little in advance of time. If anybody has any questions about some of the stuff that we covered, I'll give you a minute to type them in. We're happy to answer what we can, or if we can't answer it, we can look into it and kind of get back to you with some guidance on that. All right. Well, if there aren't any questions on this presentation, if there aren't any questions right now, again, feel free to contact us if you have any questions on the materials. Otherwise, Megan will be forwarding those out, as she mentioned, the slides and an audio to the webinar. All right. Thank you.